by the following there.
We are, I believe, live. Call the Legislative Committee on Administrative Rules to order. April 21st, 2022. First item on the agenda is to convene and review and approve the minutes of April 7th. And before we do that, we shall introduce ourselves.
Good morning. I'm Joe Benning, the state senator from Caledonia District. Did you want more? I can give more.
I remember looking for some detail. Representative Seth Baumgartz from Manchester.
And Representative Mark Higley from Lowell.
Representative Carol Odie from Burlington.
Jenny Lyons, Senator representing Chittenden County.
Representative Trevor Squirrel representing Underhill and Jericho.
Mark McDonald representing Orange County.
Oh, Anthony Dexter Cooper from the Office of Legislative Counsel. I just helped them.
And in the command booth behind us is Charlene Dindo, who keeps us on the straight and narrow. First item on the agenda is 21P23, State Board of Education Independence. Thank you. Convene, review, and approve the minutes of April 7th.
Second.
It has been moved that we approve the minutes of April 7th. Is there any discussion? If not, all those in favor say aye.
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 Opposed say nay, and the minutes have been approved. 21P23, State Board of Education Independent School Program Approval. Emily Simmons, General Counsel for the Agency of Education, is the witness we have scheduled. And Ms. Simmons, the floor is yours.
Thank you so much. Good morning. With me today is the State Board of Education Vice Chair Jennifer Samuelson, who's been designated by the board to speak to these rules.
We're having difficulty. Could you perhaps get a little closer to the mic, or
Yes, I
difficulty
can.
hearing you?
So I'm introducing the State Board's Vice Chair, Jennifer Samuelson, who's been designated by the State Board to present these rules. They are State Board rules, and the Agency of Education supports the State Board with rulemaking.
So would you like me to start off? Would that be helpful for the committee?
Yeah, go ahead.
The floor is yours.
Great. Well, thank you, everyone, for this opportunity to present this morning. I just want to start off by saying that this has been a long, thoughtful, and inclusive process. As you know, the State Board of Education was directed by Act 173 of 2018, as further amended by Act 72 of 2019 and Act 112 of 2020 to amend its rules governing the approval of independent schools. These amendments include the enrollment of students who require special education services and the provision of special education to publicly funded students. As you also know, the General Assembly created an advisory group, which was composed of individuals and representatives from 14 sectors of Vermont's education landscapes. I often refer to these individuals as the experts in the room, since their collective experience in areas of proficiency provided a great collective understanding of the background of and challenges to the education of children with special needs, as well as good recommendations as to the best ways to implement the mandates of Act 173. As the chair of the subcommittee, it was important to me to utilize this Act 173 advisory group to benefit from their collective experience, to count on their different perspectives to tease out the most difficult issues, and to trust the process that any consensus achieved adequately captured these different areas of expertise and their perspectives. In my conversations with Megan Roy, the chair of the Act 173 advisory group, we both agreed that it was more important to get the rules right than it was to get the rules fast, and to ensure that the rules successfully implemented the mandates of Act 173. During the public comment period, we had 4 public comment hearings that were scheduled, and we also received a total of 82 public comments from 10 individuals or organizations. Many of the public comments went right to the heart of Act 173, and we decided as a subcommittee that it would be helpful to send those comments back to the Act 173 advisory group to ensure that the language adequately captured the intent of the Act 173 advisory group in light of the public comments. So we kind of gave them the first pass at reviewing the public comments, while we, as the state board subcommittee, went ahead and processed the comments that kind of fell outside of the purview of Act 173. And then we rejoined our efforts to sort of bring everything to conclusion. The revisions were ultimately approved by the Act 173 advisory group by an 11-to-1 vote. And then these revisions were then brought before the state board at a special meeting on March 9th. And the motion to approve the Rule 2200 series as amended passed unanimously. I'd like to just quickly give you an overview on a few categories. And then if there are specific questions, I think Emily and I will sort of toggle between the two of us to respond to any specific questions that you might have. The first category of changes that I kind of wanted to briefly overview with you are the changes to the Rule 2200 series that have been proposed in response to public comment. First is we've made it clear that approval is conditioned upon the requirement that a school complies with all statutory requirements and the board's rules, including non-discrimination in admissions and operations, as well as requirements relative to the school's facilities, fire drills, and immunizations of its students against disease. These changes are located in Rule 2226.6, the application, as well as the counterpart in Rule 2227.8, approval. We've also incorporated in Rule 2227.12 suggestions from the state auditor's review of independent school oversight. We've responded to anticipated legislation requiring non-discriminatory school branding in Rule 2227.13. I will highlight that this provision will only have legal effect if the new requirement is enacted by the General Assembly. We've also implemented a rule requiring schools to adopt a policy on record maintenance and retention in Rule 2227.14. We've completely rewritten Rules 2229.1 and 2229.4 in response to public comment and in collaboration with the Act 173 advisory group. And we've explicitly noted that distance learning schools are statutorily ineligible to receive public tuition payments in proposed Rule 2239. In addition to these changes that pertain to Act 173, I also wanted to highlight that the following rules have been amended and will take effect upon adoption. The first is Rule 2223, General Conditions for Approval, which includes a more comprehensive and transparent process to govern the investigation, adjudication, and disposition of complaints. Rule 2224, which includes recognition of the Association of Independent Schools in New England as an accrediting agency. Rule 2226, the application, which includes explicitly calling out that any independent school that wishes to be approved, regardless of whether or not it is eligible to receive public funds, must include a statement of discrimination that is consistent with the Vermont Public Accommodations Act and the Vermont Fair Employment Practices Act. And finally, Rule 2227, approval, which includes a requirement that an independent school operating a boarding program must be accredited or licensed in order to receive approval, and further requiring that the State Board of Education finds that an independent school substantially complies with non-discrimination in admissions and operations in order to be approved. This provision applies whether or not the school is eligible to receive public funds. So I just want to conclude with my overview by saying that I was really grateful for the expertise of each of the members of the Act 173 advisory group. We wouldn't be where we are today, certainly without the support and guidance of the Agency of Education and Ms. Simmons in particular. And we've worked really hard to achieve consensus among the various constituents, the result of which is presented to you in these rules today. Our meetings were both numerous and long, but we worked hard to craft rules to implement the mandates of Act 173, and I'm happy to be bringing the rules this morning. Thank you.
Questions for the witness? Representative Bongartz.
Put it on the table. I'll move adoption of 21P23.
A motion has been made to adopt the rules as presented. Any questions for the witness? Senator Lyons.
Thank you very much. That was a very clear and comprehensive report. Appreciate it, especially with regard to the input of the advisory group. So very helpful to me in particular. My one question is on 2229, the application process I'm looking at the marked up version. But just the concern that the Vermont Legal Aid had about a child with disabilities wanting to go attend the same school as a sibling without needs. Was that resolved within the 2229 rule? How did you look at that particular request?
Emily, do you want to take this one?
Sure, thank you. Yes, Senator Lyons, it's a really good question. That question and that concern.
Could you identify yourself for the record, please?
Emily Simmons, Agency of Education. That hypothetical or that example, Senator Lyons, was one of the central cases considered in this rulemaking, and Vermont Legal Aid was a crucial stakeholder up into the very last meeting of the subcommittee. So yes, I would say that concern has been addressed. The total intent and application of Rule 2229 is to put students with and without disabilities on the same footing when considering which school to attend and going through the enrollment process.
Okay, thank you. I'm good.
Senator Benning.
Good morning. I was looking at Rule 2224, the reciprocity for approved independent schools and approved independent schools ineligible to receive public funds. And the change that's being made says, in addition to the SBE Rule 7320, which the board shall continue to recognize until July 1, 2024, State Board recognizes the Association of Independent Schools New England and the New England Association of Schools and Colleges. The deadline of July of 24, is there an ongoing process that annually reviews that recognition, or is that there for a different reason?
So Emily Simmons, Agency of Education. Senator Benning, the State Board also brought Rule Series 7000 through rulemaking this year, and that sunset is what we're calling it of 2024 was one of the amendments that's now been made to Rule Series 7000. So this really is meant to dovetail and provide additional information to folks who might only be looking at this rule to put them on notice about the sunset and the other rule series.
Okay, thank you.
Any Representative Higley?
Thank you, Mr. Chair. Maybe this is a question for Emily, not necessarily regarding the particular rule, but I just heard on the news this morning that across the country, there's quite a shortage of special educators. Is that currently the case in Vermont as well?
Yes.
And is there any special effort to remedy that, or is that, I mean, I know we've done some things, in the legislature to try to address overall teachers coming back to the workforce, but just curious as to whether or not, if there's any efforts for, and if it's affecting, schools and especially folks that do have kids that need the special education.
Yes, it is a front of mind concern for the whole education community. There is a provision in a bill in the Senate Education Committee right now that I believe is geared toward one remedy for the workforce crisis. And these rules, I would say, just to bring it back, are conscious of the fact that there might not be on hand, ready to go staffing in every school, and they provide a little flexibility within the confines of Act 173 to have flexible staffing solutions where needed.
Thank you, Emily.
Any questions for the witness? I have a question. Many of us over the years have been approached by parents who have said they were asked to sign waivers or to saying that they would not ask for or special ed services in order to have their children accepted at some schools. I think we all recognize there are several schools that perform pretty much similar to public schools and others that are more diverse in how they operate. How does the Department of Education respond to or see that that does not happen?
That was, again, one of the concerns that led to the inclusion of this rulemaking as a requirement of Act 173. So this rule would require any school that will receive public funding, so that will enroll a student whose school district pays their tuition, to be admitted irregardless of their identification as a student eligible for special education. And once accepted for enrollment, the independent school will be required as a condition of that public funding to work with the student's district of residence to provide the services that are in their district written IEP. So it won't be up to the private school to say whether the student will or won't get special education within that school.
Okay. And how do the rules spell out the enforcement for what you have just described?
The school will have to sign assurances, provide assurances, and undergo a site review to receive that upfront approval. Then, once approved, the rules clarify a complaint process and the investigations that the Agency of Education will undertake, which eventually could lead to a hearing by the state board to consider whether to revoke approval for that school.
And who would be the complainant in the example that you just gave?
A parent, a student, an educator. The Agency of Education would then investigate, and if we, so to speak, filed charges, the two parties in front of the state board would be the agency versus the independent school.
I'm trying to picture the three possible complainants. One is an employee of the school. This other complainant is the school itself. And the third possible complainant is the person applying to send their child there. Is that basically what does the agency do to enforce these rules?
I'm sorry, those were just examples. A complaint could come from anyone, including the agency itself, based on information that we find in our normal day-to-day practice and having information about the schools. There's no limit on where a complaint could come from.
When I have been spoken to, about such things, for example, we had to sign an agreement saying that we would not ask for, or we wouldn't sign an agreement. And I was asked if I could use their name. They said, no. We're trying to get our kid into a different school. Or if you use our name, because we did sign the agreement, then we're in violation of the agreement. So what does the state board do itself through its offices and through its authority to enforce the rules that the board has put forth?
I think Emily has sort of answered the enforcement part of your question, but I just want to point out too that when we rewrote Rule 2229.1 and 2229.4, if you look at the chronology, the sequencing of events, it starts with the student or the parent of the student seeking they submit the application. So that's in 2229.1 subparagraph A1. So the first step in the process is that the student or the family of the student submits the application. There is no mention at that point of any special needs. Then the school, consistent with its enrollment policies, and again, without any, knowledge or, without regard to whether or not the student has special needs, the student admits the student consistent with its enrollment policy. And then you pop over to 2229.4 for the procedure for the provision of special education services. So once that student has been admitted by the school, then the LEA and the IEP team convene a meeting with the school, the family, to make sure that those special education services are being met at the school to which the student has been accepted.
And to be even more clear, the existence of the type of agreement that you're describing, Senator McDonald, would violate these rules on its face.
So it's the board's understanding that such agreements will no longer be offered, either on paper or with a wink and a nod.
That's correct.
Yeah, it would be in violation of the act as well as the state board's rules as presented.
Thank you. It's been moved. Representative Odie.
Thank you. I'd like to read from a letter from Rebecca Holcomb, a parent and Vermont resident, also former Agency of Education Secretary. She writes here, beyond the state's authority, the state board does not have the authority to waive federal requirements for private schools serving students with disabilities. And that 34 CFR section 300.146 and 300.147 require the state to monitor the compliance of private schools serving students with disabilities when those students have been placed or referred to a private school for special education. So private schools serving students with disabilities must provide an education that meets the standards that apply to education provided by the SEA and the LEAs. So my question is, are the assurances in 2229.3 adequate? Because if they are not, then that puts school districts, which are legally responsible to be sure that they're providing that education that meets those standards, in a risky position. And there's more, but basically that's the gist of my question.
Sure. Thank you, Representative Odie. First, I'll say that it's really important to recognize Rule 2229.3, that list of assurances, is quoted directly from Act 173 itself. So to the extent there are comments that that list is not sufficient, that's, I would posit, a question beyond the scope of the rulemaking. That's a legislative question. But to really answer the question, the assurances are sufficient. That federal rule, in the context of all of our independent schools and all of our students, speaks to the therapeutic schools, the students that may live in a district that operates a school or may not a school choice student, are placed in a therapeutic school due to the nature of their special education needs. The agency approves those therapeutic schools according to those assurances and the rules. And the delivery of special education services is also under the oversight function of the supervisory union. so that in these rules, nothing has changed. The students still must be provided the education that's dictated by their supervisory union and their IEP, their services plan, and that's their federal entitlement. These rules don't do anything and could not do anything to change or dilute that federal entitlement to services. And that's the obligation of the supervisory union, to be overseeing the education of their student when they're placed out of district due to the severity of their needs.
Trust. Do you think that these rules set up a different standard for Vermont schools and out-of-state schools?
These rules primarily, and the changes to these rules primarily apply to schools in Vermont, those Vermont approved independent schools. However, when it comes to those therapeutic schools, the question is a little more clear. They must provide the same level of services as a school in Vermont, because the level of need of that student really dictates what their education will look like. And it is more frequent for a student to be placed in a therapeutic school out of state, just because of the lack of available spaces in state, and two, the diversity of need. So for instance, our residential placements tend to be out of state, and the agency and the supervisory union have oversight to ensure the student is receiving their education.
Motion has been made to approve the rules as presented. Any further questions for the witness? So, I've listened to this testimony, and this puts a lot of, there are many independent schools out there, several of which we would all march behind and applaud for their approach to the meeting the spirit and letter of these rules, and others who look upon these rules as, my opinion, unwanted interference and troublesome government meddling. And when I ask myself how the board and those charged with enforcing these rules, which will have the weight of law, I am not convinced that the board has a method to hold all these schools to the standard that its rules call for. And I find that troubling and end of sentence. Okay. Motion has been made to approve the rules as presented. Any further questions for the witness? Any further discussion? Senator Lyons.
Yeah, I understand what you have just said, Senator, and I think that there is a strong part of me that agrees. I'm very concerned that there are some independent schools that will not adhere to the letter of the rule and of the law. And it does require a lot of trust in order to ensure that students with disabilities and others are accepted and treated fairly within our educational institutions overall. I'm going to vote for the rule because I think it's an important step. I also think there's an obligation on the part of the Agency of Education and the board to ensure that there is oversight, that these rules are effectively implemented. So, and I would think that our education committees will want to have further discussion. So that's my comment.
Is there any further discussion? If not, all those in favor of the motion, say aye.
Aye.
All opposed, say nay. Ayes appear to have it. Ayes do have it, and the rules have been approved. Thank you very much for your testimony.
Thank you.
And I just thank you for answering my questions. Emily,
Thank
I
you.
just was so focused on what I was thinking about that I didn't speak.
Thank you all.
Thank you.
Oh, thanks again. 22E06, Department of Financial Regulation, Access to Healthcare Services. For the department, oh my goodness, Sebastian, I'm going to do it again.
Arduengo.
Arduengo, Assistant General Counsel of Department of Financial Regulation. My apologies.
No worries. Good morning. For the record, my name is Sebastian Arduengo for the Department of Financial Regulation. And this morning, I'll be testifying to Emergency Rule H 2022-01-E. And this rule is adopted under the authority originally granted to the department under Act 91 of 2020 and has been amended several times over the course of the pandemic, most recently in Act 85 of 2022. And given the continuing prevalence of COVID-19 in our communities, when we originally adopted this emergency rule, we were hovering at around 200 new cases reported. And yesterday, April 20th, the health department reported over 300 new cases and estimates an 11.3 7-day test positivity rate. So given the sort of continuing spread of COVID-19, the department determined that it would be prudent to extend the emergency rules for healthcare services related to COVID-19 to the full extent that the legislature has authorized under Act 85, which is until March 31st, 2023. So because this rule is an extension of what we've previously done, I'll just briefly summarize all of the components and then ask if the committee has any questions. So the substantive provisions are in Section 3, and subsection A requires health insurers to cover COVID-19 testing to the extent required by federal law, and also requires coverage of so-called specimen collection, which was an issue earlier in the pandemic. Section B, or subsection B, requires coverage of antigen tests, again, to the extent required by federal law. Subsection C requires coverage of testing when a consumer might additionally be tested for influenza or pneumonia or other respiratory illness. And then subsection D requires coverage of services associated with COVID-19 testing. For instance, if you needed to go in for an office visit for whatever reason, and you received a COVID-19 test, all of the services associated with that testing are required to be covered. And finally, in subsections F and G, we require health insurers to cover COVID-19 treatment, both in inpatient and outpatient settings, and COVID-19 prevention. And all of those services that I've just mentioned are required to be covered without member cost sharing. And I believe Vermont continues to be one of 2 states in the country, the other being New Mexico, that requires insurers to cover COVID-19 treatment without cost sharing. So that is the substance of our rule. I also wanted to flag for the committee that pursuant to the recommendation of Legislative Council, we are going to be making a couple of technical corrections. 2 of them are related to our citations to Act 85 of 2022 as the authority for this rule. As I said earlier, the authority for this rule started with Act 91 of 2020, as amended several times subsequently since then. So we are going to change those references to Act 85 in sections 1 and 6 to reference the entire lineage of acts and subsequent amendments. And then we're also going to be adding a comma in section 1 C, I believe, and all of those changes, I believe, were in the memo that Legislative Council drafted for you. So with that, I am prepared to take any questions you might have about the rule, what it covers, or the process going forward.
Senator Lyons.
Okay, just to indicate that as chair of the Committee of Jurisdiction here, that this would receive our full approval. I don't have a question for Sebastian.
Any other questions for the witness? Did it again.
What?
Representative Squirrel.
Think about that for a minute, huh?
He's got a name tag. He's got a name tag.
Right here.
He was talking to me about bears this morning in his front yard, and I knew he wasn't bear.
Anyway, it's more of a comment because in the emergency filing, emergency rules go for 180 days, and your expiration on this rule is 3/31/23. It should be 9/30/22. So I don't know where that change takes place or whatever.
So under the most recent act, which was
85.
Act 85, Section 1, it extended it out, saying they could do longer
They
than
could do
180 days.
360 days.
Yeah, they can go to April 1st of 2020.
Yeah, I didn't know that. Okay. Okay.
And that was what Sebastian said about changing the last citation in Section 6 effective dates. So it'll
Okay.
be changing this to the longer citation, which is what gives them authority to have it
Okay.
go until March.
All right, great. Thanks.
For those listening, the emergency rules around COVID started a couple of years ago, and the question we ask over and over again, and I think what Representative Squirrel's question would be feed right into is, are these rules the same that we have had, notwithstanding the technical corrections with commas and rewrites for dates? Are these the same emergency rules that we've been operating under since COVID began?
That's correct.
So with the extension of this emergency rule, are there any further questions about its content and purpose? Senator Lyons.
Just a comment. I would like to say that DFR has worked very, at least, especially in the beginning, on the initial emergency rule to coordinate this coverage by our private insurers. And it's, which was a very full process, and we all worked together on this. So I just wanted to say thank you to DFR for the work that they've done on this,
Sure.
continue to do.
Is there any further discussion? No. It may appear to those listening that we are just marching forward without asking critical questions, but these COVID rules have been established, have been discussed, have been parsed, and we still make the corrections that are getting pretty minor with commas and cites, but the rules themselves have continued as we understand them to be. If there's no further discussion, did we get a motion?
I'll make the motion that we approve EO6.
Yeah, okay. Representative Bongartz moves that the emergency rules be approved. There's no further discussion. All those in favor say aye.
Aye.
All opposed say nay, and the rule's been approved. Thank you very much.
Thank you very much.
Which brings us to E22E07, Department of Children and Families Transitional Housing Program Emergency Rule. And do we have, I do not have a witness scheduled. Oh, Heidi Moreau. Is Heidi Moreau here or someone speaking on her behalf?
Yes, she's right there.
I'm here. Good morning. I'm Heidi Moreau, Policy Advisor for the Department for Children and Families. I'm also joined by my colleague, Nicole Tousignant, the Policy and Operations Director for DCF's Economic Services Division.
Apologies for not recognizing you. We at this end of the table sit as far away from the screen as Putin does from his generals, and we can't cannot read it from this far. So thank you. Continue.
Thank you. Act 83, the fiscal year 2022 Budget Adjustment Act, authorized DCF to adopt emergency rules establishing a transitional housing assistance program funded by the Federal Emergency Rental Assistance Program. The federal program makes funding available to assist households that are unable to pay rent. These rules were developed with extensive input from the General Assistance Work Group. Members of the work group come from several community organizations, including Legal Aid, the Coalition to End Homelessness, and the Network Against Domestic and Sexual Violence. Under the Transitional Housing Program, DCF will help eligible individuals, including those who are currently receiving general assistance, emergency housing assistance, obtain occupancy agreements with motel owners. And the rules set forth the specific terms which must be included in the occupancy agreement. Once an eligible household and a motel owner have entered into a valid occupancy agreement, DCF will provide a security deposit and make monthly payments directly to the motel on behalf of the household. And this program is intended to provide more stability for households experiencing homelessness while they work with housing service providers to secure permanent housing. Finally, I'd like to note that Legislative Council did identify a few typographical errors in the rules, and DCF will file a corrected version of the emergency rules addressing those errors.
I need to leave.
Senator Lyons.
No, I'm going to say, the rules look fine to me, and I appreciate the work that you've done to bring them in. I need to leave at this point for another meeting, but I hope still have a quorum. I need to leave. Yep, okay.
Are you moving to approve?
I am moving to approve the rules.
Okay. Senator Lyons has moved to
Thank you.
approve the rules.
I can,
Are there any further questions for the witness? Representative Higley.
Thank you, Mr. Chair. I have a question on rehousing. I know that some motels have had issues with folks that have done a lot of damage. And under the rehousing piece, it talks about that the department may help in obtaining subsequent occupancy agreements with another motel or wherever. Is there any stipulation that the next housing facility or site is responsible for letting that new site know the previous reason that the families were removed from the previous motel?
There's no requirement in the rules for the previous motel to inform the next motel. In helping the household to obtain a second occupancy agreement, the department would disclose why the household is in need of new housing. And you may have noticed that there is a provision under the federal program. They're called hard to house payments. And the rules authorize the department to make a single one-time hard to house payment to that second motel as a additional assurance in case there's further damage beyond the security deposit.
Okay, thank you.
It's been moved that the emergency rule be extended, readopted. Is there any further discussion? Other than the technical changes that the witness has presented, or is this essentially the same rule that has been in existence?
Yeah.
Are you ready for the question? If so, all those in favor say aye.
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 All opposed say nay, and the rule has been approved. Thank you very much.
Thank you.
Got one more on there. 21P27, Department of Health, Hospital Licensing Rule, Request for Extension of Adoption Deadline.
Mr. Chair, I will move to approve the Vermont Department of Health's request to extend the adoption deadline for 21P27 until May 10th, 2022.
Okay. Heard the motion. Is there any further discussion? If not, all those in favor say aye.
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 All opposed say nay, and thank you very much.
Compelling witness.
That was easy.
Flawless presentation by the witness.
How many rules do we have to lose?
Thanks for the script.
And a motion has been made to adjourn, but we still have a quorum. All those in favor of adjourning, say aye. Aye. Opposed, say nay. Thank you, we're adjourned.